settle our own, Marty?
Yes, sir.
All right. Today is September the 14th, 2016. We're here for a preliminary hearing for Timothy Batts. Mr. Batts is charged with reckless homicide, tampering with evidence, unlawful possession of a weapon, and making a false report. Mr. Batts is represented by Attorney John Pellegrin. The state is represented by ADA Katie Walker and Attorney General Ray Whitley. Everyone that's going to testify at this hearing, please stand and raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, General, who's your first witness? Okay, is rule requested?
Yes, Your Honor.
Okay, the other witnesses, if you'll wait in the back, please. And the witness you called, come on up, sir. Please use the microphone. This hearing is being recorded. And speak loud so we don't have any problem here, okay? Yes, sir. All right, you can adjust the microphone. You're a pretty tall fellow. You can scoot it up if you need to. All right, General.
Please state your name.
Brian Brooks.
You work for the Hendersonville Police Department, is that correct?
Yes, that's correct.
How long have you worked there?
Just over a year and a half.
What is your position?
I'm a police officer.
Well, I'd like to turn your attention now to the reason I am. You were involved in the investigation of the death of Timmy Batts on August 8th of this year.
Yes, that's correct.
How did you become involved?
I was assigned to the zone where the hospital is located, and on a roll call, we received a call saying that there had been an 11-year-old girl shot, and I responded to the hospital.
When you arrived at Hendersonville Hospital, what did you first do?
I went up to the emergency room door. We have a code as police officers to let us in. I used the code. Unable to get in, the hospital was on lockdown. A nurse came to the door and let me in. Walked in, and to the left of me, there was a trauma room. There was several doctors and nurses, medical personnel working on a young girl. I was told that was Tamia in the room.
At that point, what did you do?
I was told by one of the nurses that she was in there. They said that Timothy Batts, the father, had brought her in, and he was in a waiting reception area outside of the trauma room, and so I went to go speak with him.
Did you have an opportunity to talk to him?
I did have an opportunity to speak with him.
Do you see Mr. Batts in front of you?
Yes, ma'am, he's sitting over there,
Can you identify him as
wearing the black clothes.
What was the nature of your conversation with Mr. Batts?
I went up to Mr. Batts. I was there to gather his information for the report to be done. I began to talk to him about what happened. He stated that he had been asleep in his house.
When you say she, what do you mean?
Tamia.
When he was asleep in his house and then what happened?
He stated that Tamia walked into the house and he was awoken by her coming in stating that she had got shot. I asked Mr. Batts if he had heard anything unusual that resembled a gunshot. He said he had not. He also stated that he didn't own any guns or there was no weapons in the house. Mr. Batts said that he believed that Tamia had been shot outside of the house after getting off of the school bus.
Is that the end of your conversation, Mr. Batts?
He stated that he was awoken by her, saw her standing in the hallway holding her abdomen, chest area. He said that he could see blood coming from out and around her hands. Mr. Batts said that he was obviously very concerned, said that he picked her up and rushed her to the hospital, and that was where he was.
After you talked to Mr. Batts, what did you do?
I collected all of his information I needed, date of birth, personal information. I was told by a supervisor that that was enough. I released Mr. Batts. I told him Tamia was being transported by life flight to Vanderbilt Hospital, and he said he was going to leave in his vehicle to head to Vanderbilt to get a head start and try to be down there by the time Tamia arrived.
Anything further at this time, Your Honor?
Mr. Pellegrin.
Officer, did you do any additional investigation beyond that, or was it turned over to somebody else at that point?
My primary role was at the hospital collecting his information, and I collected Tamia's clothing.
All right. And other than interviewing Mr. Batts, is there anyone else that you interviewed as part of your role in this investigation?
No, sir.
That's all I have this witness.
Okay, anything else, gentlemen? All right, thank you, officer. You step down, or you're free to leave. Call your next witness.
Okay, calls Chris Gagnon.
Okay, ask Officer Gagnon to come in. Officer, don't go back there, stay out here, okay? You stay out here, you're free to go, either way. All right, officer, if you'll have a seat there, please. And please use the microphone. Talk loud.
Please state your name.
Detective Chris Gagnon, Hendersonville Police Department.
How long have you worked with the Hendersonville Police Department?
Almost 10 years.
That you were a detective there?
Yes, ma'am.
Were you involved in the investigation of the Timmy Batts?
I was.
How did you become involved?
I was notified in the office that we had a child en route to Vanderbilt who had been shot, and they asked me to respond.
So you went to Vanderbilt Hospital?
Yes.
What did you first do when you arrived?
Made contact with security down at Vanderbilt, and they advised that the child hadn't made it there yet. We determined it looked like some of the family was there, and I was able to make contact with Mr. Batts.
Who was present when you made contact with Mr. Batts?
There were several family members.
Did you have an opportunity to talk to him?
I requested to talk to him. He came into the security office with 2 other family members and the mother of the child at one point.
So when you talked to him, were you alone or did people stay?
They were people there.
What was the nature of your conversation with Mr. Batts?
I was trying to figure out what was going on, so I had not been updated on anything up to that point. He finds that he didn't really have any information to provide. He said that his daughter came in and said, "Daddy, Daddy." He looked down, saw she was bleeding, and scooped her up and rushed her to the hospital.
After you talked to Mr. Batts, what did you do with him?
The hospital staff came back and retrieved Mr. Batts and the child's mother because the child was passing, and took them back to the back. I finished filling out the HIPAA paperwork so that I could go back and conduct the investigation. About the time I got back there, they were letting them know that the child was passed, and things in the hospital got a little bit chaotic because everybody was upset. Mother remained back in the back for a little while, and Mr. Batts headed back towards the front.
At some point in the course of your investigation, did you return to the Hendersonville Police Department?
I did.
What did you do when you arrived?
Since I couldn't find Mr. Batts at Vanderbilt, whenever we got back, we were trying to locate him so we could talk to him and try to figure out exactly what had happened. And I made contact with, I believe it's going to be his stepfather, Jeffrey Starnes. And Mr. Starnes said that he wanted to come up and talk to me personally over everything, kind of straighten everything out. And he showed up a little while later with Mr. Batts.
How long was Mr. Batts accounted for from the point that you saw him at Vanderbilt until you saw him at the Hendersonville Police Department?
It was several hours.
Did you talk to Mr. Batts at the Hendersonville Police Department as well?
Just long enough to let him know that Detective Harris didn't want to talk to him.
Did you have further involved in the investigation at the Hendersonville Police Department?
Once Detective Harris got done speaking with Mr. Batts, he had learned that they were going to be able to recover the weapon that was used in the incident, and he arranged for me to follow Mr. Batts' cousin to go retrieve the weapon.
Where did you go?
Dickerson Road and I-65 at the Waffle House. He met with another guy that he had called ahead of time, and we recovered the weapon there.
Can you describe the weapon that you recovered?
It was a Glock with .357 on the side. Had a .40 caliber magazine inside the weapon. Whenever it was handed to him, his cousin had threw the weapon out. Whenever he transferred it over to us,
Whenever we inventoried everything with it, it was a 22 round magazine with 21 cartridges in it.
What kind of barrel did you guys have on
I can't testify completely to that because I don't know. It didn't have any markings on the barrel. Mr. Brown, which is the cousin, said that it had been exchanged out with a .40 caliber barrel, which was consistent with the .40 caliber magazine that was found in it.
After you retrieved the gun, did you have further involvement in the investigation?
No.
I think further.
All right, Mr. Tolan?
Yes, Detective Gagnon, as I understand it, your first involvement was at Vanderbilt Hospital, is that correct?
Yes, sir.
And what were you told prior to your arrival?
That there'd been a child shot.
And where did you get that information?
Sergeant Vaughn.
And you arrived at the hospital and you talked with Mr. Batts, is that correct?
Shortly after arriving, yes.
And is he the first one you talked to?
No, the first person I talked to was security.
Okay. And after talking with security, is Mr. Batts the next person you talked with?
Yeah, I went outside looking for him and found him out there, and they pointed me over to him, and I invited him back in to speak.
Okay. And after talking with Mr. Batts, you mentioned there were other family members. Did you talk to anyone else?
I talked with the child's mother, and I don't know who the relation is with everybody I was speaking with. I spoke with a few people outside briefly, and I think his sister came into the room with us when we were talking.
And just generally talking to those people, what did you find out?
And nothing really.
And after you left the hospital, what did you do then?
I went back to the police department.
And when did you start looking for Mr. Batts?
Immediately.
And what did you do trying to find him?
We ran through some databases, found some phone numbers and addresses. We checked out a couple of addresses that didn't turn back to anything, and then I located a telephone number. I think came back to his aunt, made contact with his aunt, and Mr. Starnes got on the phone.
Okay. And then Mr. Starnes and Mr. Batts then showed up at the police department?
Later on in the evening, yes.
All right. And at that time, there was no warrant for Mr. Batts?
No.
All right. And so he voluntarily came. Did he come because he knew you were looking for him, or do you know?
I mean, they knew that we were looking to talk with him.
Okay.
And I know that Mr. Starnes said that he was going to bring him up there to clear everything up, so.
Okay. And so Mr. Starnes and Mr. Batts voluntarily came up?
Yes.
All right. And at that time, there was no warrant for him or anything?
No.
All right. That's all I have. Thank you.
Okay, anything else, gentlemen?
No, Your Honor.
Okay, thank you, Officer Gagnon. You're free to step down. Your next witness?
State calls Neil Harris.
Okay, Officer Harris, if you'll have a seat there, please use the microphone. Okay, Joe.
Please say your name.
Neil Harris,
Where do you work?
Hendersonville Police Department.
What is your position?
I'm a detective assigned to the Criminal Investigation Division.
How long have you worked with the Hendersonville Police Department?
11 years.
Are you involved in the investigation of the death of Mia Batts on August 8th of this year?
Yes, ma'am.
What was your involvement? How did you become involved?
I was initially asked to contact, initially had very brief details of what occurred, what we thought occurred, and was asked to interview the bus driver who dropped Mia off near her home that day.
Did you make contact with the bus driver?
Didn't.
Why were you asked to interview the bus driver?
The initial story that I was given, or we suspected that she may have been shot after she got off the bus before she made it to her house. So I was asked to interview the bus driver, and I spoke to her to find out if Tamia had made it, if she had seen Tamia, if she had seen her make it to her house, that kind of thing.
Do you know where this initial information came from?
Interviews with Mr. Batts.
And the bus driver was going to speak to you.
Yes, ma'am.
Did you learn information from the bus driver that was helpful to your investigation?
Yeah, the bus driver was basically able to eliminate the idea that she may have been shot before she made it to her home.
With how the information that you received from the bus driver affect your investigation?
Once we knew that, Detective Carroll was obtaining a search warrant for the home, and we wanted to search inside the home. At that point, we assumed that the shooting had taken place within the home. So I went to the scene, and when the search warrant was obtained, I was part of the initial entry and walkthrough of the home.
Where did you make your point of entry into the home?
When I arrived, the garage door to the home, the overhead garage door was open, and we walked into the garage and went through the door from the garage into the house.
Did you notice anything unusual when you first walked into the house?
When I first opened the door, I noticed on the door frame there was a red substance on the door frame that looked consistent with blood that was in the shape of a pad of a finger, like a fingerprint.
This might like to direct you step by step through the walkthrough.
Okay.
So once you entered through this door, where you saw a red print that looked like a fingerprint on the threshold, where were you? What room did you find yourself in?
We were basically going into the kitchen area.
Did you find anything of note in the kitchen?
I noticed next to the kitchen table there was small shoes consistent with child shoes and a book bag neatly placed together on the floor next to the kitchen table. And that was the only thing that initially jumped out to me in the kitchen.
Once you saw the shoes in the backpack neatly placed, what did you do next?
We kept walking through the downstairs of the home, and we made it to kind of where the dining area leads into the living room area. We observed a hole in the wall that appeared consistent with a bullet hole. On the adjacent walls on either side of where the bullet hole was, we saw small red spattering that appeared consistent with high-velocity blood spatter.
Did you investigate the hole that you found?
Not while I was on the scene. That did occur during the investigation and search warrant. The bullet was recovered from the hole.
Do you know the caliber of the bullet that was recovered?
It's still TBI being tested. Ultimately, as we went further in the home, we recovered a shell casing, which is 40 caliber.
Say that again, I'm sorry.
As we went further through the home, we recovered a shell casing for the master bedroom floor that was 40 caliber. The bullet that was recovered from the wall appears to be consistent, but we're still awaiting testing to confirm that.
Can you describe the location of the 40 caliber shell casing that you found in relation to the bullet hole that you found on the wall?
Yes, again, the bullet hole was on a wall, a short wall that separates the living room and kind of dining room area. And then we walked into the master bedroom, which is downstairs off of the living room. As we approached the master bedroom, we noticed a shell casing on the floor in the middle of the room at the base of the bed. Where the shell casing was would be consistent where if someone was standing near that shell casing, looking into the living room and would fire a gun, they could have hit the wall where the bullet hole was.
So after you discovered the 40 caliber shell casing on the floor of the bedroom, what did you do next?
I finished a walk through the house, and my other detectives that were with me stayed on the scene to continue processing the scene for evidence. At that point, I left the scene and returned to the police department. I wanted to try to make contact with Mr. Batts and family of Mr. Batts to try to see if I can make contact with him to get a statement.
Did you know at that point where he was?
I didn't.
Were you able to locate him?
Ultimately, while I was still trying to locate him, I was informed that he had arrived at my office and wanted to talk to me. And he had his family with him.
You know about what time that was that he arrived?
I don't know off the top of my head. I want to say it was around 10 o'clock, but I can't remember for sure.
How long have you been unable to locate him?
Well, the incident was initially reported to us at 2:57 that afternoon. So it had been a number of hours. And Detective Gagnon previously had contact with him at the hospital. And it had been several hours since then that we've been working to try to locate him.
Who was with the defendant when he arrived at Nursing Home?
I'm sorry?
Who was with the defendant when he arrived?
A number of family members and friends, his pastor, it was a number of people.
Did you speak to Mr. Bass?
I did. Again, when he arrived there, he told me that he wanted to tell me about what happened. Him and I went and sat down in a room off of the lobby area in our office, and his pastor came to sit in the room with us, and he had family in the lobby area, and I left the door open at their request so that they could hear what was being said. And we sat, I let him explain to me what happened.
What did he explain to him?
Mr. Batts told me that he'd been out that afternoon driving around looking for yards to cut. He explained that he cuts grass, and that he was driving around looking for any grass that may need to be cut, and that he had arrived home and had gone to bed in the master bedroom, and that he was just dozing off to sleep when he heard a sound. At that time, he got out of bed and picked up a gun, and as he approached the doorway leading from the master bedroom into the living room, she made a sound and jumped out in front of him, and he fired one shot that struck to me. Mr. Batts went on to say that the gun that he had, I asked him about the gun, he said that the gun that he had was his cousin's, who had, that he left the gun at his home several days prior, and that he kept the gun under his dresser in the master bedroom, and that's where he had recovered it from. He went on to say that he assumed at the time that he heard the sound that his home was being broken into, which is why he grabbed the gun and went to the door and fired a shot. He did not realize at the time that it was Tamia. I asked Mr. Batts about previous statements he had given to Officer Brooks and Detective Gagnon, and he confirmed that those statements were not the truth. He stated that the reason he told them what he did is because he believed that if he told them the truth about what happened, he would have been arrested at that time, which, and he said he wanted to be able to stay with Tamia, he wanted to be a part of whatever was going to happen, and he didn't want to risk being arrested. I asked Mr. Batts about whether or not he was a convicted felon. He stated that he had a felony drug charge when he was younger. He was a convicted felon. I asked him, of course, you know, you're not supposed to have a gun. And he said that he knew that, but he didn't. It's not his gun, it's his cousin's gun. His cousin left his house.
I'm trying to stop you right there.
I'm sorry.
It was left at the house?
Yes, he said his cousin had been over there the previous Saturday and had been drinking and didn't want to drive with the gun in the car when he'd been drinking, so he left the gun at Mr. Batts' home.
Well, what about the day of the incident? Did you recover a handgun from the home?
No, there was no gun in the home. And during my interview with Mr. Batts, he stated that his cousin, he didn't explain exactly how his cousin got the gun, but stated that the gun was not at the house. He believed the gun had gotten to his cousin, and that it was likely at his cousin's house in Nashville.
Did you search underneath the resident?
We didn't during the initial search, or at least not to the extent where I guess we would have recovered it if that is where it had been placed. when he explained that it had been under the dresser, he mentioned that the gun box that goes to the gun was under the dresser. And I asked the detectives that had done the thorough search of the scene about the gun box, and they had not located it. So with Mr. Batts and his girlfriend's consent, the detective returned to the scene and sure enough recovered the gun box from under the dresser that appears to correspond to the gun we recovered.
Why do you say it corresponds to the gun that you recovered?
It's the gun that we recovered is a Glock. There was a barrel inside the gun box that appears to be for a .357 Glock. The Glock that we recovered is somewhat unique in that the barrel of the gun had been, even though it's a .357 caliber Glock, the .357 barrel had been removed and a .40 caliber barrel was in the gun when we recovered it, which of course is the caliber of the shot that we believe was fired. So they match up in that respect, in that there's a barrel in the box that appears to have come, we believe, from the gun because it appears to be a .357 barrel.
Detective Harris, when you did a walkthrough execute the search warrant at Mr. Batts' home, did you notice any sort of security system in place?
I didn't notice it. I was only there a brief time doing a walkthrough before I left the scene. Was notified by the detectives doing a thorough search of the scene that they located the cameras and that there was no on-site storage for the cameras, so we believed it was being stored off-site. So as soon as I learned that, I was very concerned that there may be some attempt to destroy or delete whatever video there could be of the incident. And I began contacting the security company, ADT, to try to do whatever we could to preserve any video that may exist.
Were you successful?
Yes, we ultimately received 4 videos from ADT that show parts of what happened. The video does not record consistently. It appears to be motion activated. And it took substantial motion to activate the camera. So we have 4 short clips that show portions of the incident.
Did you recover any information? Let's back up. Did you watch the videos?
Yes, ma'am.
Was there anything of note on the videos or on the investigation?
Yes, ma'am. On the day of the incident at approximately 2:44 p.m., it appears that Mr. Batts arrives home. He comes inside. He's talking on his cell phone, and he has a gun in his hand at that time. He walks in the direction of the master bedroom, and 5 minutes later, there's a video that shows Tamia coming home from school. She walks in, appears to be perfectly fine at that time, has a backpack on, and then a minute or so later, there's another video clip that begins with Tamia jumping up and down as if she had just been shot, and he picks her up and carries her out of the house. The final clip is Mr. Batts coming back into the house, grabbing what looks like a pair of shoes and something else that I wasn't able to decipher, and running back out of the house.
Detective Harris, during the course of your investigation, did you run a check of Mr. Batts' criminal record?
I did.
Were you able to locate a criminal record on Mr. Batts?
Yes.
Your permission to your search?
You may.
Now, Statement Center, as State's Exhibit 1, preliminary hearing, certified copy of the felony conviction of Mr. Batts, or attempted possession of drugs under 25 grams.
Correct. Without objection, we'll admit that. Need short to loss.
Your Honor, the video recording didn't pick up KB at all.
Repeat that on the microphone here.
Now, the statement of standard evidence of State's Exhibit 1 for the preliminary hearing, a certified copy of the conviction of the defendant, Mr. Batts, for attempted possession with intent under 0.5 grams of cocaine.
All right. Without objection, we'll allow that to come in. We just need the witness to identify.
Any document, do you recognize it?
Yes, ma'am.
What is it?
It's from the criminal court in Davidson County, showing a conviction Mr. Batts had for possession with intent to sell over half a gram of cocaine.
Is this the conviction that you discovered when you ran a criminal record check of Mr. Batts?
Yes, ma'am.
Permission search for your record.
You may.
Statement of standard exhibit.
We'll mark it exhibit number 1.
2006?
Correct, that's right.
Detective Harris, the house that you searched, that in Hendersonville?
Yes, ma'am.
That's Sumner County?
Yes, ma'am.
Nothing further, Your Honor.
All right, Mr. Coder?
Thank you, Your Honor. Detective Harris, as I understand it, the first person you really interviewed was the bus driver.
Yes, sir.
All right. And based on information you found out from the bus driver, is that what led you to do the search warrant?
That was part of it. There was obviously several of us involved in the investigation at that point. There was other information being collected from other areas that I was not part of. I know that was made part of the evidence for the search warrant as well. But certainly the statement of the bus driver contributed to that.
And other than the bus driver, was there anyone else that you interviewed prior to getting the search warrant?
Prior to the search warrant, I believe the only person I interviewed was the bus driver.
Okay. And once in the home, you said that you saw what appeared to be some blood on a door facing, and where was that again?
It's when you first go into the home from the garage into what leads you into the kitchen. It's kind of a small foyer area that goes into the kitchen. On the door frame, when you first open the door on the left side, there was a print that looked like the pad of a finger. It was in red, consistent with blood.
Okay. And you also saw some additional blood splatter in the home?
Yes, it appeared consistent with blood spatter, yes.
And where was that?
It was, there's a short wall that's just 3 feet or so deep. It comes out and partially separates the dining area from the living room. And right on the end of the wall, it's only 5 inches or so wide. There was a bullet hole right at the end of that wall, and there was blood spatter on either side on the adjacent walls.
And additionally, I think you said you found a shell casing on the floor?
Yes, in the master bedroom.
Okay. And I'm a little unclear about the gun. The Hendersonville Police Department feels confident that they have the gun that was involved in this incident. Is that correct?
Yes.
All right. And at the time Mr. Batts showed up at the Hendersonville Police Department wanting to talk to you, there was no warrant on him. Is that correct?
That's correct.
All right. And Mr. Batts told you, as I understand it, that if he had told what he told you at the police department, that if he had told that initially when he first talked to the officers, that he was in fear of being arrested and wouldn't have been able to be with his daughter, that's probably true, isn't it?
I'm not sure. There was discussion that night after I spoke with him of exactly what, if he would be arrested, what he would be charged with. I'm not sure if he would have given that statement initially. A lot of our suspicion came from the fact that as the investigation continued, we felt like we weren't getting the truth from him.
Sure.
So I'm not sure how that would have turned out if he would have given the truth initially.
Okay. But certainly it was a reasonable fear that if he'd have told what he told you at the police department from the very beginning, certainly there was a reasonable chance he would have been arrested.
Yes, it's reasonable.
All right. And the information Mr. Batts gave you about the gun, that helped you to retrieve the gun, is that correct?
Yes, he couldn't tell me where it was, just that his cousin had it, and his cousin was able to help facilitate the recovery of the gun.
And as far as you know, you were able to retrieve all the video that's relevant in this situation?
As far as I know.
You know evidence that there was any effort to delete or destroy any video evidence?
There was an attempt to log into the account twice right after the incident occurred. What that person's intent was, I'm not sure. They were unsuccessful because they had the wrong password.
Okay. And you don't know who that person was?
Not yet.
Okay. That's all I have. Thank you.
Okay, anything else, gentlemen?
Yes, Your Honor. Detective Harris, did the video that you recovered come up in your conversations with Mr. Batts?
No, because we didn't have it. It came up in the respect that that it existed. We knew there was cameras. He told us there was cameras. But we didn't have the video, so we couldn't discuss specifically what was on it. He just informed us that it would show what happened and that what he did was accidental.
Nothing further.
Okay. Anything else?
No, Your Honor.
All right, thank you, officer. You can step down. Any other witnesses on behalf of the state for the preliminary hearing? All right, Mr. Pellerin, any witnesses on behalf of Mr. Batts?
Judge, pursuant to Rule 5, don't wish to put on any proof to negate probable cause. Judge, one of the charges against Mr. Batts is tampering with evidence. The proof up to this point has shown that when the officers went in to investigate, that there was a shell casing found on the floor, that there was what appeared to be a blood fingerprint on a door frame. There was blood splatter there. Mr. Batts showed up at the police department later voluntarily without a warrant being on him. He told them, gave them information that helped them retrieve the gun. He gave them information about, or at least told them, that there was a video available. Judge, there's no evidence before the court that I discerned that Mr. Batts did anything to tamper with evidence. And with regard to that particular charge, I'd respectfully ask that that be dismissed.
Gentlemen.
Your Honor, under the statute, there refers to tampering of evidence. It is tampering to conceal any object or thing with the intent to impair its credibility as evidence. And Your Honor, states that is what occurred here. The officers went and their search warrant. There was no weapon found in the home. It was only retrieved. There was some weapon. Your Honor, I would submit, and we're not sure right now whether or not it was the actual weapon that was used, but there was some weapon that was retrieved later on in the city. And that would be sufficient, Your Honor, as proof of probable cause on that charge.
All right, I do think there's probable cause. The weapon was there. The weapon disappeared. The police were able to find the weapon based on later statements Mr. Batts gave. But in the beginning, the weapon did disappear for some reason. I think there's at least probable cause, so I respectfully deny the motion. Anything else?
Not with regard to criminal.
Okay. All right, Mr. Batts, I do find the state's carried the burden of proof of probable cause. I'm going to bind all of these cases over to the grand jury. There will be an arraignment date of October the 21st up in Judge Gay's court. So that will be the next court date. Now, the state has a motion filed to revoke Mr. Batts' bond. And we're going to go into that hearing. Are there other witnesses that are going to testify from both sides?
We have other witnesses, Your Honor.
All right, are all those witnesses here?
I will need to check.
All right, let's bring all those witnesses in. I'll swear them in.
And Your Honor, if I could be excused about 10 seconds.
Sure, sure. witnesses?
Yes, Your Honor.
Any other witnesses? Okay, everyone that's going to testify, please raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, who's your first witness?
Brian Reynolds, Your Honor.
Mr. Reynolds, you'll come up as a rule requested.
No, Your Honor.
All right. Ladies, y'all have a seat right there on the front row. Sir, if you'll please speak into that microphone. This hearing is being recorded, and speak loud. All right, gentlemen.
Please state your name.
Brian Reynolds.
You work for Community Corrections.
Yes, ma'am.
You're in the Gallatin office.
Yes, ma'am.
How long have you worked here?
5 months.
During the course of your employment with Community Corrections, have you come into contact with the defendant, in this case, Timothy Batts?
Yes, ma'am.
When?
The, July 13th.
What was it his initial report date? To your knowledge, was it his initial report date
Yes,
that you
ma'am.
met him?
Yes, ma'am.
You heard about the time in the morning it was?
10:40.
Why did you meet with Mr. Batts?
Because when he reported, he had to see his case officer, and because his case officer is a female, I had to do his drug screen.
Well, tell us how you administer a drug screen.
Whenever we do a drug screen, I go up front, I get whoever is doing the drug screen, the individual, I take them back to the restroom. Whenever we go back to the restroom, I show them the sign that's on the wall that says, you need your pants and underwear must be pulled down to your knees. And I'll give them the cup and the urinating cup.
Can you pull that microphone closer to your mouth, please? Can you describe the restroom? Is there anything unusual about it?
It has mirrors along the wall, that way you can see.
Can you describe the container you use for a urine sample?
It's just our standard Aegis Lab container.
Well, how can you tell if there's something in a urine sample that tests positive for a drug?
If it's positive, we only have one line. If it's negative, we'll have 2 lines.
Okay, so there are strips inside the urine container.
Yes, ma'am.
Now, how did the protocol that you just described compare with your drug screening of Mr. Batts?
His was a little bit different because he could not submit a large enough sample. So I can't remember if it was 4 or 5 different times. So we had to go back and forth from the lobby to the restroom and back and forth until he finally got enough of a sample.
How long did that take?
It was close to an hour.
What happened to the sample container between attempts?
He initially made it, and it was in his possession.
So he kept the same container during all
Yes, ma'am.
45 attempts? Did you keep the defendant within your eyesight when he made each attempt at urinating into the container?
Yes, ma'am.
Were you with the defendant the whole time that he was at Community Corrections?
No, ma'am. Whenever he could not use the restroom, he would go to our lobby, and our secretary would sit there on it.
At any point did you watch him in the lobby?
Yes, ma'am. While our secretary was taking a break.
Was he allowed to leave the lobby?
No, ma'am.
Did you see the urine container?
Yes, ma'am. It was sitting on the ledge on the counter.
And was he required to keep that container with him?
Yes, ma'am.
At some point, did he accumulate enough urine to provide a sufficient sample?
Yes, ma'am.
And did you get a result from that drug test?
Yes, ma'am. It said positive for cocaine.
As a result of the drug test returning positive for cocaine, what did you do?
I done the steps necessary to get it ready to get sent to the lab. We signed the sheet. There's a front sheet. He has to put his social security number, write his name, and then at the bottom he has to date the initial 2 strips that I place below the container crossways so it cannot be opened and tampered with. And then after he fills that out, I put the piece of paper in the bag with the drug screen, and the bag has a tamper seal on it as well. And I close that, and this whole time it's in his eyesight. Then I put it in the fridge.
So while you were going through this process, where was Mr. Betts?
He was standing right beside me.
And the last thing you did with the container was what?
Put it in the fridge.
Did you tell Mr. Bass about the result of his drug screen?
I asked him if he had taken any cocaine, or used any cocaine.
What was his response?
He said no.
Did you have any further interaction with Mr. Bass?
No, ma'am.
Nothing further, Your Honor.
Okay, Ms. Bowden?
Do you know how many drug tests Mr. Batts has taken total with community corrections?
1 a week, ever since this report day,
Okay. And when was the most recent one?
this morning.
All right. And as far as you know, he's passed all the other ones?
Yes, sir.
All right. And you may or may not know this, but do you have any knowledge that he's taking some on his own?
I couldn't hear you, sir.
Do you have any knowledge about him taking some additional tests other than the ones y'all have given?
Yes, sir. He brought in the papers this morning. I seen wherever he handed them to his case officer that he had written down other tests done by himself.
Okay, so he's had some independent tests done at your understanding?
Yes, sir.
All right, and he's passed all of those?
Yes, sir.
And at the time you told him that he failed this first test, he denied using any cocaine?
Yes, sir.
All right, that's all I have, thank you.
Okay. Anything else?
No, Your
All
Honor.
right, thanks, sir. You step down. Are you next witness?
State calls Jennifer Woodard. Please state your name.
Jennifer Woodard.
You may have to scoot up or move the microphone back. You work for community corrections?
I do.
As a case officer?
Yes.
As a case officer, do you at times supervise people while they are out on bond?
I do.
Did you supervise the defendant Timothy Bass on bond?
Yes.
Do you know when he was placed on bond?
He was placed on bond on August the 12th, 2016.
When was the first time that you met with Mr. Bass in person?
I met with him in person on August the 15th, 2016.
Prior to August 15th, had you spoken to Mr. Bass?
The morning of August the 15th, he called the office at 8 o'clock to make arrangements to report. And that was the first time that I spoke to him.
What's the nature of your conversation?
He called to see what the protocol was for reporting. I explained to him that he needed to be at the office by 9 o'clock to report. He said that he would like to wait a little bit longer to view the body of his daughter and to make arrangements for the funeral. I told him we only had a certain amount of time before or after release from the report, and he just needed to come on in, and then he could have the rest of the day for anything that he needed to do. And he said, okay.
So did he report on August 15th?
He did.
What time did he come in?
10:40.
Did you meet with him personally?
I did.
Did you see the defendant in the courtroom today?
I did.
He described he's wearing.
He is wearing all black.
How long did you meet with him?
We met for probably 20 minutes.
As one of his bond conditions, were you required to drug test Mr. Bass?
We are required to drug test him once a week when he reports. Mr. Reynolds does the drug screens, of course.
Was Mr. Reynolds was present that day?
Yes.
And administered the drug screen?
Yes.
You're aware of the result of the drug screen?
Yes.
And as a result of, what was the result?
He was positive for cocaine.
What did you do as a result of the positive?
I filed a motion, or submitted a letter to the court explaining that he had failed a drug test. It had been confirmed positive by each laboratories.
Is it standard protocol to send these drug urine samples off to EPs for additional testing?
Yes, any panel test that is positive, we send for any sort of additional confirmation.
Now, at this time, the state would request permission to approach.
You may.
Ms. Wood, are you be drug tested weekly. Your Honor, at this time, the state would like to submit as a state's exhibit, state's collective exhibit 1 for this hearing, certified copies of the affidavits and the bond form when he was released, which state the bond conditions in this.
All right, without objection, we need the witness to identify.
I'm handing you a document. Do you recognize it? I do.
The first page is the affidavit of complaint with the bond conditions at the bottom, signed by Judge Hunter.
Would you turn to the last page, please? Okay. Do you recognize this one?
I do.
What is it?
This is Mr. Batt's bond information where he made bond with Oldham Logging Company.
Your Honor, at this time, the state would like to retrieve and ask the permission to enlist the state's exhibit.
All right.
I'm sorry, Judge, I didn't hear.
She asked for it to be entered as exhibit number 2.
Your Honor, I believe this would be collective exhibit 1 to the specific hearing.
Oh, well, yeah, it would be exhibit 1 to the bond hearing. You're right. All right, Ms. Butterwell, any other questions?
No, Your Honor.
All right, Ms. Butterwell.
Yes, Ms. Woodard, he has taken, as I understand it, several other tests with community corrections since then,
Yes, yes,
and he's passed all of those.
yes.
And was he scheduled to take one this morning?
He was not.
And he showed up and asked to be given a test?
Yes.
All right. And he's also provided you with information that he's had some tests done on his own and has passed all those as well?
He did.
That's all I have.
Okay. Anything else, gentlemen, on this witness?
No, Your Honor.
Okay, ma'am, you're welcome to step down. Thank you. Call your next witness.
Your Honor, the state calls Amy Hoffman.
If you come up and have a seat, please. And please speak into the microphone.
Please state your name.
Amy Halfin
Where do you work?
at Aegis Sciences Corporation.
Spell your last name for me.
It's Halfin, Halphen.
Okay.
What does Aegis Sciences Corporation do?
We're a drug testing laboratory, and specifically at Aegis Analytical Laboratories, we do forensic urine drug testing for workplace.
How long have you worked for Aegis?
Over 5 years now.
What is your position?
I'm a laboratory director for Aegis Analytical Laboratories.
As laboratory director, what are your general duties?
I'm responsible for the day-to-day operations of our laboratory, including training technical staff. I also certify and review data and report results, and maintain our certifications through various state and regulatory agencies.
Are you the custodian of records?
I am.
I'd like to talk to you about your educational background. Can you tell us about your educational history?
Yes, I have a bachelor's of science in biology from Mary Washington College, and a master's of science in forensic science, specializing in drug chemistry and toxicology from Virginia Commonwealth University.
Prior to working at Aegis, where did you work?
At Alere Toxicology in Richmond, Virginia,
How long did you work there?
approximately 4 years.
I could talk to you about your training. What kind of specific training have you had?
I have training from Alere Sciences as well as Aegis Sciences. We have what's called Aegis University. I've been through the certified scientist class there. Part of our training is normal corporate training for certified scientists, so even as lab director, I was required to go through those training procedures as well.
Do you hold any specific certifications?
Yes, I'm registered with the National Registry of Certified Chemists as a toxicological chemist. I also am licensed by the state of Tennessee as a medical laboratory professional.
Are you published in your field?
I am. I have poster presentations at the American Academy of Forensic Science and an immunotoxicology paper.
Ms. Halpin, what is drug toxicology?
Forensic urine drug toxicology or drug testing is essentially what we do to understand whether a donor has recently used drugs. So we're looking for specific drug analytes in urine in this case.
Have you previously testified as an expert in court?
I have. I was qualified as an expert witness in Virginia, West Virginia, Florida, Tennessee, and specifically in Sumner County and Davidson County, Tennessee.
How many times have you testified as an expert in court?
Over the past 9 years, 50 or more times.
And in what field specifically have you testified as an expert in?
In forensic urine drug testing.
I could talk to you about AEGIS. Does AEGIS have a specific certification that's mentioned?
We do. We're certified by the National Laboratory Certification Program. And that program is administered by the Substance Abuse and Mental Health Services Administration, which is a subset of the Department of Health and Human Services. And that's a federally regulated agency that certifies approximately 30 labs across the country.
What is involved in maintaining that accreditation?
We've been accredited since 1991, and part of maintaining that accreditation is 2 inspections. Twice a year we're inspected by 2 inspectors that come on site for 2 days. They're going to review our SOPs, they interview our technicians for proficiency, and at the end of those 2 days of inspections, we receive a report back that we need to respond to within 2 weeks regarding any deficiencies we may have in the laboratory. And then they will continue our certification based on those inspections. In addition to the inspections twice a year, we're subjected to proficiency testing 4 times a year. And that's when every quarter throughout the year we receive 25 to 26 specimens that are sent to us from an outside agency. They mimic urine drug samples that are positive for, particularly most of the samples or drugs of abuse that we can test for under the regulated program. And part of that proficiency testing is to ensure that we are not only accurately identifying drugs, but we are also reporting them correctly. And we submit those reports back to the NLCP, and again, a few weeks later, we receive essentially a report card back from them defining any discrepancies.
How many urine sample drug tests does AEGIS process in a given day?
Specifically at our analytical laboratory, our average is about 450 samples a day.
Your Honor, at this time, the state moves to enter Amy Halpin as an expert in forensic drug testing.
All right, any objection?
No, Your Honor, don't wish to cross-examine her on.
All right, we'll qualify the witness, Ms. Halpin, as an expert in this field.
I'd like to turn your attention at this point to the step-by-step process involved in testing a urine sample. How is a urine sample received at AEGIS?
Right, so we receive urine samples through a courier. A lot of those samples are through FedEx or a local courier, as in this case. Once we receive the sample, it is sessioned in our laboratory by trained forensic evidence processing technicians. They are first looking for the integrity of the sample, that has been maintained, specifically that the tamper seal on the specimen is intact and has not been tampered with. That's one of the initial things that they look for when they receive a sample. They will also check that the identification number on the sample bottle matches the identification number on the chain of custody that we received with the sample. They're going to make sure that the test panels are properly identified, and then they will set those samples up for what we call our initial drug screening process.
You mentioned the chain of custody. Can you explain to us how your chain of custody works?
Yes, we have several different chain of custodies. The custody and control form is what most people are familiar with, and that is the initial form that is signed by the collector and typically by the donor. There's typically 5 parts to that form. We received copy 1 of that form in our laboratory, and that initiates chain of custody in our laboratory. So once it's received, our accessioner will then identify the date, their signature, their stamped name, as well as they will indicate if the specimen integrity seal is intact. And And then there's another chain of custody that will follow the original bottle that we received throughout the laboratory. And then the third type of chain of custody is a chain that will follow an aliquot or a small sample of urine that's poured from the original bottle. There are several different aliquots for several different types of testing, so there may be several different chain of custodies to follow different aliquots.
So after a drug goes through the accessioning department, what happens to it?
So the majority of our drugs are negative, or our samples are negative and get released within that day. When we have a presumptive positive on our immunoassay screening, that is reflexed into our laboratory information management system, and that notifies our team members in the accessioning department that that sample needs to go on for further confirmation testing. As a forensic rule of thumb, we release positive results based on 2 different testings, typically 2 different methodologies, and that's why we use the screening initial assay and then additionally the confirmation assay, which is more specific.
How is a urine sample stored in between testing and imaging departments?
That is all documented on the chain of custody. The samples and aliquots have to be within the line of sight of the technician who documents that it is in their possession. If it is not within their line of sight, or they have, or they don't have possession of it, then they need to document on the chain of custody where they are storing the sample in a secure manner. Our accessioning department in particular has restricted access to team members that only need access to that department. All of our team members at Aegis have fobs or card keys, and depending on what their role is in the laboratory, depends on what access they have to different laboratory departments.
Let's talk about the testing methodology used on the urine sample provided by Timothy Batts in this case. Are you familiar with those methods?
Yes, there were 2 different methods. The first one is the initial drug screening method. We use what's called CEDIA reagent for that process, or clone enzyme donor immunoassay. It's a very common reagent that is approved, and we do use it for our federally regulated testing program as well. It's based on an antibody-antigen reaction. So typically, the screening assays are very sensitive, but not particularly selective. So there may be some cross-reactivity that would occur on a screening assay. And that's why it's important for us on a presumptive positive test to then send a sample on to confirmation testing. The confirmation testing is different because it uses gas chromatography and mass spectrometry. And that is considered one of the gold standards for confirmation testing in the forensic drug testing industry. Until 2010, that was the only methodology that we were allowed to use for confirmation testing. And essentially, the GCMS testing is specific for an analyte. It essentially looks for what we call a molecular fingerprint. So it's unequivocal evidence of a specific analyte. And in this case, we were looking for benzoylecgonine, which is one of the primary metabolites of cocaine.
The immunoassay, is that technique widely used?
It is.
Is it generally accepted by the scientific community?
It is, and it's one of the techniques that we are allowed to use under the federal program.
That technique has been tested.
Is that, I'm sorry?
That technique has been tested?
Yes.
Do you know the rate of error?
I do not know a specific rate of error for that.
What about the, I'm going to call it the GCMS, the gas chromatometry mass spectrometry test? Is that widely used in the scientific community?
It is. Gas chromatography mass spectrometry is considered the gold standard for confirmation drug testing.
Do you know the rate of error?
In our laboratory, in most forensic laboratories, for quantitation purposes of an analyte, we are held to a plus or minus 20% quantitation variability. And that's why we use quality control in our assays, because that is something that ensures that we are quantitating the drug correctly.
How many drug tests test has Aegis processed using these two methods?
Well, we've been using these two methods since 1991, so I can only extrapolate from there. Our healthcare laboratory brings in about 3,000 samples a day. Our analytical laboratory brings in about 450 samples a day. So doing the math, that would be a pretty significant portion of all of our testing.
I'd like to turn your attention at this point to Timothy Batt's urine sample.
Yes.
How long was it stored before it was tested?
We received the sample on August 16th, and testing was conducted on August 16th for the immunoassay.
Permission to approach, Your Honor.
You may.
A document that consists of 3 pages. Can you identify it?
The first document is an affidavit for Claire Kendall, who is a certifying scientist in our laboratory, and she was a certifying scientist that released the results for the GCMS confirmation of benzoylecgonine. And the last page is our Aegis laboratory report.
At this time, the state would like to introduce the state's Exhibit 2 in this hearing, the affidavit and the accompanying test results.
Without objection, we'll mark that Exhibit 2 to the, on here. You'll hand that over to me, please.
What were the results of the testing done on urine sample of Timothy Bass?
Timothy Batt's lab sample ID 2347291 was positive for benzoylecgonine, which is a cocaine metabolite, at 149 nanograms per mil.
What is the window of detection for this cocaine metabolite?
Typically up to 3 days or 72 hours.
In your expert opinion, what does 149 nanograms per milliliter of this cocaine metabolite indicate as far as the recency of the usage of the drug?
There is some variability in drug concentration in urine depending on how fast a person metabolizes a drug. But the general consensus is that at 149 nanograms per mil, that this is a positive sample, meaning it was used within the past 3 days prior to this testing.
Nothing further.
All right, Mr. Golden.
Yes, Miss, is it Halpern?
Yes, sir.
Okay. And I've talked to more than one person at Aegis Labs, and forgive me, you and I have not spoken?
Yes, sir.
Okay. And as I understand it, you're the director of the lab?
Yes, sir.
And you're not the one that actually performed this test?
Correct.
All right. And as I understand the procedure at Aegis Labs, even though this was Mr. Batt's urine sample, he's not entitled to a portion of that sample to have retested because, as I've been told, the client is Community Corrections, and they're the ones that have to request it. Is that correct?
It is, our client is Community Corrections. Donors typically have the right to request a send out sample for additional testing at another laboratory.
Okay. You know why I was told that the only way I could get it was to get a court order?
No, sir.
Okay. And once I got a court order, do you know why I was told that I couldn't send it to the lab that the order said?
My belief was that the order was for any lab test now, which is not actually, is a third-party administrator, not a laboratory. So Dr. Black, our CEO of Aegis Sciences, made the recommendation to send it to a SAMHSA certified laboratory. And then I believe a conversation with Dr. Robert, he requested or encouraged that MedTox would be an appropriate laboratory to send the aliquot to, or LabCorp request.
All right. And I think the lab he recommended was in Minnesota.
I'm not sure. I'm sure we're going to
And the list that I was provided that came from Aegis of the labs that they dealt with, there are only 31, I think, in the U.S. and Canada.
Correct. Those are SAMHSA certified laboratories.
And y'all don't send them to any other labs?
We recommend SAMHSA certified laboratories because that is one of the most stringent certifications, and we trust the results from a SAMHSA certified laboratory.
And I was told that even if I requested to be sent to one of the certified labs, that the results would be sent back to Aegis and not to me. Is that the way that works?
Correct. Usually we will receive, since we are at that point the client of Lab B, they will send us the results, and then we relay the results to the appropriate party.
And other than Aegis, there aren't any other labs that have this certification you mentioned in Tennessee?
No, there are not in Tennessee.
That's all I have.
Anything else, Shirley?
Your Honor. Ms. Halpin, did the defense make a request for the urine sample to be retested?
I believe there was a request sent. It was not sent directly to me, but the request was for it to be sent to any lab test now.
If the request had been made to send it to a SAMHSA certified laboratory, would that request have been honored?
Yes.
Was the request made to send it to a SAMHSA certified laboratory?
Not to my knowledge.
I think you further, Your Honor.
Anything else?
No, that's fine.
Ma'am, will you step down? Any other witnesses?
No further witnesses, Your Honor.
Okay, anybody on behalf of Mr. Bass?
No, Your Honor.
All right.
Your Honor, I have a motion to make.
Okay, sure.
Your Honor, I move to dismiss the state's motion. First of all, Judge, if I can explain a little bit about the lab. Requested an independent sample. Was told by Aegis that we were not the customer and were entitled to it unless absent a court order. Got a court order. They said they wouldn't comply with the court order because the lab that we were going to send it to wasn't one of these certified labs. They recommended somebody in Minnesota. Despite the cost prohibition and all of that, even if that had been done, it was going to be sent back to Aegis, not to us. To us, that's not an independent test. I just wanted to explain that to the court.
Sure.
But Judge, the state has failed to carry their burden of proof under State versus Dowell, and I'll hand a copy of this to the court. The bond condition has to be reasonably related to the defendant's ability to show up in court. Judge, this is a case out of Sumner County, shepherdized, it's still good law. And in ruling in this case, they said there was no evidence presented in the instant case suggesting that this particular defendant presented a flight risk due to his illegal drug use. Instead, it appears that the trial court orders that all defendants released on bond must refrain from illegal drug use. Interestingly, the bond in this case does not provide that the appellant shall consent that the drug strains a condition of release. It merely states, by order of the criminal court, the use of illegal drugs is a violation of this bond. This court, I'm talking about the appellate court, does not dispute the fact that illegal drug use is a violation of the law. However, if a defendant is charged with a drug offense while released on bail, the trial court is authorized to increase and now revoke even the bond. In addition, statutes governing bail cover situations when a defendant fails to appear. This court cannot accept that the trial court's blanket prohibition of illegal drug use reasonably relates to assuring the presence of all defendants who are released on bond. Without any specific finding of a flight risk due to illegal drug use, the trial court's unnecessary imposition of the drug screen was not reasonably related to assuring the appellant's appearance in court. Moreover, this court does not agree with the state's broad proposition that even absent specific factual findings of a flight risk due to illegal drug use, a defendant's illegal drug use is likely to cause him or her not to appear for a scheduled court hearing. Evidently, the appellant in this case used illegal drugs yet still appeared for the scheduled hearing. There appears to have been no probable cause for the drug test of the appellant, and it is evident that the appellant did not consent to the same. The trial court orders the screening upon simple request of the state. This case, I will tell the court, is different in that this was done apparently in court, and said this court has some concern about the constitutionality of the warrantless search. However, the propriety of that judgment of contempt is not currently before the court. Judge, I think the law is clear that even if Mr. Batts had failed a drug screen, even if we conceded that he did while on bond, and we don't, but even if we conceded that he failed a drug screen while on bond, it would be our position that unless there's some showing at this hearing that he will not show up in court as a result of illegal drug use, that the state's motion simply fails. They've not carried the burden of proof that's required of them under the law. Additionally, Judge, it's interesting to note Ms. Halpern testified that this was, she would expect that this indicated drug usage within 3 days. This test was given about 3 days after he made bond. We all, and I'm not saying this is what happened, I don't have an explanation, but there's not proof before this court to revoke someone's bond that he used within the period of time that he made bond. This was 3 days after, and that's right at the time she said that she would expect that it would indicate the usage. So there's no proof that he used, I would submit to the court, during the time that he made bond, number one. But number two, there's no proof under State versus Dowell that he's not going to show up in court as a result. And he's taken multiple tests since, both on his own and with community corrections. He showed up this morning again, voluntarily wanting to take a test even though he wasn't scheduled to, and he's passed every one of those tests. He's not a flight risk, and his bond, obviously $500,000, is huge for a Class C and Class D felony, and I just don't think there's any showing under the case law that he's a flight risk, and therefore the motion should be denied.
Okay, Joe?
Your Honor, the state's position is that we have met the burden of proof in this matter. Your Honor, we presented 3 witnesses. Start with Jennifer Leary. She explained that the defendant, she is his case officer, requested to put off meeting with her. Your Honor, that when he was required to come in that day, he came in later than he was supposed to come in. That it took him an hour to accumulate enough urine to provide a sufficient sample. That sample was positive. Your Honor, that sample essentially was tested 3 times. First with community corrections, and then twice with Aegis. You heard Amy Halpern testify, and she explained as an expert in this matter that the gas chromatometry mass spectrometry test is the gold standard in testing. It is quantitative. It gives a very specifically defined amount of this cocaine metabolite, for which it was positive as 149 nanograms per milliliter. And she testified that it's indicative of use within the past 3 days. Your Honor, if he didn't use it, it's when he made bond. When did he use it then? When he was in jail? Or the night that these charges were pressed against him? Your Honor, the state submits that the proof has shown that he used it, in fact, when he made bond. And Your Honor, the state would recall the statements made by Your Honor when his bond was reduced, when he was given these bond conditions, that these bond conditions were imposed that Your Honor expected him to follow them and that Your Honor would hold him to these bond conditions. The defense cites State versus Down, but it overlooks a very important factor under 4011-118, Your Honor. That is the safety of the community, as well as the risk of flight. The defendant has shown a disregard for this court's rules, a disregard for this court's orders, and that disregard should be considered when deciding whether he is a flight risk. Additional bail conditions, Your Honor, State submits are not enough. He has already shown that he cannot follow the bail conditions imposed on him. And the State would point to the safety of the community. Specifically, under 4011-118, the factors of his character, his prior criminal record, the nature of the offense, and how that relates to his danger to the community. The State would point out, Your Honor, that his felony conviction that was submitted as evidence today was for attempted possession with intent to sell cocaine. Your Honor, it was cocaine, and that is the same drug that he violated his bond condition for, that he tested positive for, and a urine sample that was tested 3 separate times. This speaks to his character, it speaks to his criminal record, and the likelihood that because of that record he poses a danger to the community, and Your Honor, the nature of the offenses with which he is charged are egregious. Now, the State would also like to point to Statute 4011-150. These are the domestic violence bond conditions. And the State would submit, Your Honor, that if he were allowed to remain on release, if there were additional bond conditions imposed, or if the bond amount that he received was increased, that he is required by law to be placed under these domestic violence bond conditions as well, which have specific results for any sort of violation that occurs while he is out. Your Honor, cumulatively, based on the evidence we presented today, it is clear that he violated the condition of bond imposed by this court. Your Honor, that given his record, given his character, given his disregard for the court's rules, that he could be a flight risk and that he is a danger to this community, the State would request that his bond be revoked.
Anything else?
Yes, Judge, the things that she talks about, the prior record, the circumstance of the offense, all of those things are things to be taken into consideration when setting the bond, and those were all taken into consideration, I'm sure, by Your Honor. Also, Your Honor, I think what Your Honor actually said at the time, not that it really, frankly, makes a lot of difference with regard to the issues before the court, is that in the event he violated a condition of his bond that Judge Gay would revoke him. Judge, we're just asking, there's no proof, zero proof, that he is a flight risk. There's zero proof in this hearing regarding the safety of the community or anything else that would justify revoking this huge $500,000 bond. The State filed this motion. The burden of proof is on the State. The law under State versus Dow is clear as a bell, and the State has simply not shown anything required by the law. And because of that, we'd ask that this be dismissed.
Your Honor, we have a response.
All right.
Your Honor, the State would refer this court to State versus Bergens. That is a Tennessee Supreme Court case that was decided more recently than the Court of Criminal Appeals case in State versus Dow, and deals specifically with bond revocation, Your Honor. It does cite 4011-118. It explains that the State's burden is preponderance of the evidence, and that the court should consider when determining what option is appropriate if he finds that the State has met its burden, whether additional bail conditions should be imposed, whether bond should be revoked, or bail increased. And he has to consider whether that would assure the appearance of the defendant at trial and protect the safety of the community. Must also consider the bail factors listed in Tennessee Code Annotated 4011-118. So these factors, the nature of the offense, his criminal record, his character, Your Honor, and frankly, disregarding the court's orders are relevant to this proceeding.
Judge, Bergens is totally different. Bergens doesn't refer to Dow. Bergens doesn't overrule Dow. If you if you shepherdize Dow, it's good law. It's not been modified in any way. Bergen's was a case where somebody on bond got new charges. That's not what we have here.
Okay. Anything else? All right. When we had the first bond hearing for Mr. Batts, we set out certain conditions. I did reduce his bond. He was going to be supervised by community correction, had to report weekly, take drug test, told him he couldn't get any new arrest, couldn't leave the state, had to follow the rules of community corrections. Any of those conditions that they violated was subject Mr. Bass to some new bond conditions or revocation possible. I'm familiar with the Dow case because it did come out of Sumner County, out of our criminal court here. In that particular case, Judge Gay had a blanket rule that everybody gets drug tested if you're on bond. If you violate or fail a drug test, your bond could be revoked or changed. And I do understand Mr. Peller's argument from that case. It does say that, let me find it. It says, while the trial court may consider the protection of the public safety when setting the amount of bond, the restrictions on the activities, movements, associations, and residences of the defendant imposed by the trial court must be reasonably related to assuring the defendant's appearance in court. And the court goes on and talks about it, and they reversed that revocation of bond in that particular case. That is a Court of Appeals case from 2009. There's been a lot of controversy in the state over revoking bonds and setting bonds and conditions of bonds, and as a result, we have now a Supreme Court case, Tennessee Supreme Court, State versus Virgins, that came out just last year, April 7, 2015, which I know both attorneys are very familiar with. And they set out some rules. They say before a judge can just revoke a bond, put a person in jail because they violated some condition, you have to give them notice of the hearing. A motion has to be filed. You just can't go have it picked up, thrown in jail. So we had a motion filed in this case. The attorneys did the absolute right thing. We had a motion filed. He got notice of the hearing. He had time to prepare for the defense. Witnesses were called, testimonies given. And that's what this hearing is about today. And that was one of the procedures this case set out. Now, that probably should have been done all along, all the time, but it wasn't. But now we have this directive from the Tennessee Supreme Court, so we have these hearings on bond. And it talks about what the court can do in considering whether or not a bond can be revoked or changed. In this particular case, this lady was charged, she made a bond, got out, and then she got a bunch of new charges, like 19 new charges, one of which was a first-degree murder charge. And so the judge in that case revoked her previous bond. Now, it sets out certain things that the court can do. It says at the close of the proof, talking about the bond hearing, if the trial court finds the state is shown by preponderance of the evidence, that's not your burden of proof in a regular criminal case. In a regular criminal case, it's beyond a reasonable doubt. In this type of hearing, it's by preponderance of the evidence, which is a lot less burden of proof. If the state shows by that burden of proof that the defendant has violated a condition of release, comma, has committed a criminal offense while released on bond, comma, or has engaged in conduct resulting in the obstruction of the orderly and expeditious progress of the trial or other proceedings, then the trial court may, and it gives several options, may revoke the bail and hold the defendant until trial, or continue bail with the possibility of additional conditions or an increased bond amount. In determining which option is appropriate, the trial court should consider, one, whether any additional bail conditions or an increased amount of bail would assure the appearance of the defendant at trial and protect the safety of the community under Tennessee Code annotated. So the case, Court of Appeals case from the Dow case talks about whether or not the bond condition had anything to do with the defendant showing up for court. In the Tennessee Supreme Court case, they talk about if the defendant violates one of the conditions that were set by the judge, and in this case we had specific conditions. It's not a blanket order like was in Dow, but we had specific conditions we made the defendant aware of specifically before he left that day. We put it all in writing and told him, and he knew that. The court says if they violate one of those conditions, and I find that he has violated that condition, and he failed a drug test for cocaine, he hadn't picked up any new charges, he has not failed to report to the supervised bond community corrections, he's not done those things, but he did fail a drug test. Now, while I'm on that, let me say this. He was arrested August the 8th. That was on a Monday. We had the bond hearing Friday, August 12th. I reduced his bond. He got out of jail that night, I believe. He took this drug test the following Monday, August 15th, and that's when he failed the test. According to the testimony, cocaine only stays in your system 72 hours. So that goes back to the Friday that he got out of jail when he made the bond, or early that morning on Saturday, whenever that was. But it was in that time frame that he got out. Let me see if I have that. I'm looking at the bond, there's not a date on it, but yeah, there is. August, it was like 12th, which is that Friday that he made the bond. So I do find he's violated the bond condition. Now, what do we do? I think under the Supreme Court case that was decided last year, I can consider any of these options they set out because it not only has to do with appearing in court, but it has to do with the safety of the community, and they specifically state that in this decision. So the reason we put the bond condition of taking drug tests on Mr. Bass was because he was convicted about 10 years ago, almost 10 years ago, of sale of cocaine. And he had some other misdemeanor drug convictions before that, so we made a bond condition that he has to take drug tests. Another reason I did that was because at that hearing it came out there was video surveillance showing Mr. Bass walking around with his arm with a gun in his hand while he's on the phone. That concerned me greatly. So I can do nothing. I can't raise his bond. It was, $500,000 bond. That's where we said it is a very substantial bond. I think that's a large bond. I can bump it back up higher than that. I can make it $1 million. Does that do any good for anything? I don't think it affects anything. To raise the bond higher. I can put more conditions. What conditions would I put? He's already reporting weekly. He's already required to take drug tests. He can't move. That's a condition. I don't know what other conditions I could put on Mr. Batts that would make a difference here. Apparently, he's not used since he failed his first drug test. They tested him weekly. He's passed those. He's had some other tests that apparently he has passed. But I'm just concerned about the drug use. Cocaine is a bad drug. It's a very addictive drug. He's already been through this a few years ago. Mr. Batts, I'm sorry, but I'm going to revoke your bond and hold you without bond. Do not applaud.
What can I do? Can I get back in my I can't ask for sign this form. Q, he's got to sign that, right? I'm ready to get back in court. He's got some paperwork. She just got it right there. What's this for? Sign right there.
Next, your payment will be October 21st. I think I told you that earlier.
Stand up for me.
And that will conclude this hearing. Do we have Sarah Hall and Peyton Walker? All the parties and witnesses and attorneys in that case, please come up. And we need federal law, and also somebody can ask you.
Teddy Shaw, courtroom. Teddy Shaw.